Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina's weekly business meeting. Today is June the 17th. It is a 11:11 a.m. We're starting 11 minutes late. Please accept my sincerest apologies. We're still working through some technical issues with our brand new TriCaster. So we're working to better serve you, but we ask that you be patient with us. Let's take a brief moment of silence. All right, let's take roll. Present here in the hearing room, we have Commissioners Caston, C. Williams, Powers, Belzer, and J. Williams. Joining us virtually, we have Commissioners Irvin and Thomas. Attorney Butler, would you please read the agenda?
Yes, sir. Thank you, Mr. Chairman. Good morning, Mr. Chairman, other members of the commission. The commission has an administrative agenda this morning, but before we get to that, the first order of business would be to set the next meeting for the commission, which staff would suggest would be Wednesday, June 23rd, 2021 at 11 a.m.
All right, thank you, sir. The next business meeting will be June 23rd at 11 a.m.
Thank you, sir. Moving to the commission's administrative agenda, have an item under docket number 2005-83A. Staff presents for commission consideration a review of the Public Service Commission's public communications.
All right. I'm going to pass the gavel to Vice Chair Belzer.
Thank you, Mr. Chairman. Any discussion or motion on item 1 on the administrative agenda?
Vice Chair Belzer.
Chairman Williams.
I have a motion. Randy Erskine, if you could roll that video footage, please.
Yes, sir. Just a minute. You see my screen?
No. There we go.
You got it? Okay, I'm starting it now.
This might be an appropriate thing for me just to interject something. We're aware of the tweet. It's issue number 9 in their brief. They're walking on eggshells because they got to go back before the Public Service Commission. So they don't ask for any specific relief, but they want us to know about the tweet. And I know it didn't come from you. It came from Consumer Affairs that the PSC retweeted it. So it doesn't have your fingerprints on it at all. But I think we wanted to say today how disturbed profoundly we are by that tweet. The PSC is a quasi-judicial body. And for them to have a victory tweet and reveling in the defeat of a party is beyond the pale and is grossly unprofessional. We've reviewed the record and we don't think there was any inherent bias among the commissioners. Maybe some administrative assistant at PSC pushed a button and retweeted this. But the PSC had better be sure about what they tweet in the future. It will not be tolerated.
Thank you, Randy Erskine. Melissa, if you could activate the Elmo or the Grover, I guess that's the new name. Might want to enlarge that just a little bit. That's a little too much. So that video speaks for itself. Just to give a little bit of background, that was oral arguments in front of the South Carolina Supreme Court. Occurred yesterday. And that was the court speaking through Justice Kittredge about communication made by the Public Service Commission. And it's pretty strong in my opinion, and I believe it should have been strong because in order for us to maintain credibility, we must abide by the Code of Judicial Conduct, and not just the lawyers, and not just the commissioners, but all the employees at the Public Service Commission of South Carolina. We're held accountable to that. Now, I'm showing this chart because this chart, organizational chart, shows leadership. Obviously, you have the commissioners at the top. We're going to be held accountable for our leadership, fellow commissioners. Now, I happen to sit in the seat of the chairman currently, so you see the little bit of supervisory, if you want to call it that, authority I have over my fellow colleagues. It's slim. I can't tell anyone what to do, but I can lead you all to the water and hope that you drink it. And then below the commissioners, we have our chief clerk, who helps us regarding management of the rest of the staff. And so I just wanted this to be a teachable moment for the commission, so that we govern ourselves accordingly with all of our public communication. Now, in this instance, it happens to be social media, but it's not limited to social media. Social media is a great tool. It's probably the biggest achievement in human communication in my lifetime. Maybe more is to come. This is really not just about social media. It's about all of our public communication. And I think it is wise for us to examine ourselves to make sure that we understand the weight that we carry as employees of the the Public Service Commission of South Carolina. We are held accountable to the Code of Judicial Conduct. Other agencies may not be, and they may conduct themselves in a different manner than the Public Service Commission. But the Public Service Commission is held to that standard, the Code of Judicial Conduct, as Justice Kittredge said, quasi-judicial. And it's a tough word, quasi-judicial. I think that word comes from case law. Quasi means, partially, or, almost, but not really. But I'll tell you, we're held to the complete and full Code of Judicial Conduct, not part of it, all of it. And we're responsible to make sure that not only we govern ourselves accordingly, but also that we make sure our employees, our direct and indirect reports, are also abiding by the Code of Judicial Conduct. And I want to show the preamble. If you would, Melissa, please activate the Grover again. The reason that this is so important and why I'm taking some time on this, and this is the Code of Judicial Conduct. I just want to read the preamble. I may reference a few pages. And it reads, our legal system is based on the principle that an independent, fair, and competent judiciary will interpret and apply the laws that govern us. The role of the judiciary is central to American concepts of justice and the rule of law. Intrinsic to all sections of this code are the precepts that judges, individually and collectively, must respect and honor the judicial office as a public trust and strive to enhance and maintain confidence in our legal system. The judge is an arbiter of facts and law for the resolution of disputes and a highly visible, that's important, highly visible symbol of government under the rule of law. And so as a commission, when we have parties that come before us that don't follow the rules and we enforce the rules, it comes across a big hollow if we don't abide by the rules that we are supposed to abide by. And so, this is important. Canon 1, a judge shall uphold the integrity and independence of the judiciary. A reads, an independent and honorable judiciary is indispensable to justice in our society. A judge should participate in establishing, maintaining, and enforcing high standards of conduct, and shall personally observe those standards so that the integrity and independence of the judiciary will be preserved. The provisions of this code are to be construed and applied to further that objective. Again, a high standard of conduct, observing those standards, preserving the integrity and independence of the judiciary. paper. And Canon 2 reads, the judge shall avoid impropriety and the appearance of impropriety in all of the judge's activities. A judge shall respect and comply with the law and shall act at all times in a manner that promotes public confidence in the integrity and the impartiality of the judiciary. Canon 3. A judge shall perform the duties of judicial office impartially and diligently. Judicial duties in general, the judicial duties of a judge take precedence over all the judge's other activities. The judge's judicial duties include all of the duties of the judge's office prescribed by law. In the performance of these duties, the following standards apply. And I just want to skip forward here. To paragraph 5, a judge shall perform judicial duties without bias or prejudice. A judge shall not, in the performance of judicial duties by words or conduct, manifest bias or prejudice, including, but not limited to, bias or prejudice based upon race, sex, religion, national origin, disability, or age, and shall not permit staff, court officials, and other judges subject to the judge's direction and control to do so. Melissa, I'm finished with the Grover. So again, I just want to remind my fellow colleagues, the commissioners, our executive director, and all of our employees that we are subject to the Code of Judicial Conduct. Reminds me of a story that happened in my life when I came home and asked my mother if I could get an earring and wear baggy pants. And she said, no, you can't. And I said, well, everyone else is doing it. Why can't I? And I'm quoting her and saying, because you ain't everybody else. And so I just want to let the Public Service Commission know we're not everybody else. We can't do what everyone else does. We have to maintain a high standard. And if we don't, our credibility is destroyed, and heeding the appropriate warning from the Supreme Court, the South Carolina Supreme Court, we may have some big issues if we don't, because we're on notice. And I would like to keep my law license so I can feed my family, and I'm sure all the lawyers here would like to keep their law licenses so we can feed our families, and the Supreme Court can take it away. And so we need to take this seriously. And we need to be mindful of our words and our actions and make sure we do everything in our power to abide by the law. And to that end, I move that there be a stand down of social media activity and non-essential public communication for a week. Or let me ask the executive director, do you think we can have something ready by the 23rd, executive director board, or do you need until the 30th?
I think for us, I'm concerned about some of the pending matters that are coming before the commission, Mr. Chairman. So we're already less than a week, really, because the 23rd will be next Wednesday.
Would the 30th be appropriate?
I think the 30th is better. I would like, would you finish you didn't finish your motion, did you?
No, ma'am.
Would you finish your motion and then may I comment?
Yes, ma'am.
If I may.
Yes, ma'am. And so I do not want to, so the motion is substantially complete. The only thing missing is the date that our activities will come off this temporary stand down. And the purpose of the stand down is just to examine ourselves, examine our public communication, examine our thinking, just to make sure that we're not only in compliance with the law, but we're doing things that make sense. So I'm going to give deference to you, Executive Director Boyd. If you think you can have something And when I say something, a new way moving forward, or a proposal from the staff,
Yes, sir.
and how we conduct ourselves in the future. If you could get it done today, that would be fine. I know, and I'm not suggesting that you should, but what I don't want to do is send the wrong signal or send the wrong message that I want to limit or cut off the folks who consume content via social media or any other content. I don't want to go dark on them for too long, but I do want us to take time to pause and to recognize the importance of our role here, all, not just commissioners, but all employees, and how we must abide by the code of judicial conduct in our public communication.
Okay, with respectfully, Mr. Chair, I want to ask. I wrote down, you said stand down of all social media activity, and you said and that's as far as
Non-essential public communication. And my definition of non-essential, obviously, notices have to be sent out. We need to respond to emails, inquiries, things of that nature. But I understand we have a few publications, we have a few social media platforms, and so that's what I identify as non-essential.
okay. I think Mr. Attorney Butler mentioned the commission asking that the commission meeting next week be scheduled for next Wednesday.
Yes, ma'am.
So I'm asking for clarification here. So that would, an example, an event that has been posted on the website, announced by the commission, would not be on social media based on your motion.
An event, you
Such
mean
as next week's commission meeting and the link to the live stream.
that's
video.
fine. That's fine
Okay,
doing the stand down.
That's what I wanted to. That's what I want to clarify. So the stand down does not include perhaps, and you say that, please, sir, if that's your if this is your intent, if the event is posted on the commission's official website and under its docket management system as an event that is occurring at the commission, for example, the meeting next week or a hearing, that staff, based on your motion, will be allowed to post those events on social media only.
Yes, ma'am.
Okay.
Well, when you say post on social media only, well, that's not the
Post those events only. Let me make sure I put the word only, place it in the right place. Only post on social media those events that have been effectively noticed on either the commission's website, www.psc.sc.gov, or on its docket management system under the commission calendar.
That's correct.
All right.
Commissioners, you've heard the chairman's motion with the clarifications given by him to questions from our executive director. Any comment or discussion? We'll proceed to a vote. Chairman Williams, since it's your motion, I will start with you. Chairman Williams.
Aye.
Commissioner Powers.
Aye.
Commissioner Carolee Williams.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
And I vote aye. The motion carries. Mr. Chairman, I will turn the gavel back to you. Thank you.
Thank you, Vice Chair Belzer. Attorney David Butler, please continue presenting the agenda.
Yes, sir. Thank you, Mr. Chairman, other members of the commission. It's time now to move to the commission's utilities agenda. Item number 1 is docket number 2021-153S. It's having to do with Palmetto Wastewater Reclamation Incorporated. Our staff's presenting at this time for commission consideration the customer bill insert timeline proposed by commission staff.
All right. Thank you, sir. Is there a motion?
Mr. Chairman, this is Commissioner Thomas.
Commissioner Thomas, you have the floor, sir.
I move that the commission approve the bill insert timeline as will be stated. I further move that requests for extensions to any of these dates be referred to a hearing officer for action. The schedule is as follows. The application filing date is 6/16/21, and that deadline has been met. The newspaper publication date, 7/16/21. The deadline to email or mail bill inserts to customers is 8/16/21. The intervention deadline 9/6/21. The applicant direct testimony is 9/2/21. Other parties of record direct testimony is 9/30/21. Applicant rebuttal testimony is 10/14/21. Public hearing for customers, 11/8/21. And a second potential public hearing for customers is 11/9/21. Other parties of record rebuttal testimony is 10/28/21. The hearing date is 11/10/21. And the order due date is 12/16/21. I so move.
Thank you, Commissioner Thomas. Hearing Commissioner Thomas's motion, is there any discussion? Hearing no discussion, we'll vote starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer.
I vote aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, item number 2 on the utilities agenda is docket number 2019-224E and 2019-225E. We have the integrated resource plans for Duke Energy Carolinas LLC and Duke Energy Progress LLC.
Is there a motion? Commissioner Caston.
I move that the commission find and conclude that the integrated resource plan, the IRP, with its 6 portfolios in totality, combines to make the integrated resource plan of Duke Energy Carolinas LLC and Duke Energy Progress LLC, the Duke companies, submitted for commission approval. This proposed Duke IRP, together with modifications and clarifications provided by Duke, does satisfy the requirements of South Carolina Code annotated section 58-37-40. This IRP, including its modifications and clarifications, should be accepted and approved by the Commission. The base case presented by Duke represents the most reasonable and prudent means of meeting the electrical, utilities, energy, and capacity needs as of the time the plan is reviewed. As the agency charged with the responsibility of interpreting and enforcing Section 58-37-40 and Act 62, the Commission must determine whether the integrated resource plan is the most reasonable and prudent means of meeting energy and capacity needs. The Commission, in its direction, shall consider whether the plan appropriately balances additional factors. I further believe that there are differences between this docket and other IRP dockets, as well as in the approaches used by a company to prepare its IRP. Having reviewed the evidence before the Commission, it is my opinion that the Duke IRP includes the requirements of Act 62 and that it represents a reasonable and meaningful resource plan. The record is replete with testimony concerning whether the company asserts an appropriate plan as opposed to a preferred plan. Whether a specific portfolio has been indicated as being preferred or appropriate, in my view, is not part of the plan contemplated under Act 62. These two words, appropriate and preferred, are, in my opinion, functionally equivalent for the purposes of this proceeding. I would additionally note that if one reads all of Act 62, the word preferred simply does not appear. In fact, witness Snyder does testify that the base plan is the appropriate portfolio. The statute is primarily an outline of all that the IRP must have or contain to be satisfactory. Similarly, I believe that our analysis and evaluation should focus on the elements emphasized and required by Act 62. Therefore, I move that the Commission accept and approve the Duke Company's IRP together with the modifications and clarifications provided in the rebuttal testimonies and exhibits of the Duke witnesses. The integrated resource plan must be a working document that is updated as new information becomes available. The Commission understands that a preferred plan is one of many best management practices. While not specifically required in Act 62, I move for the approval of Duke's IRP, which is predicated upon Duke's commitment to comply and that Duke must comply with the request of ORS to change, modify, and enhance the future IRP updates and IRPs beginning with the 2021 update due in September 2021 from the Duke companies. The approval of this RFP will be discussed in more detail in our order. I so move.
All right, commissioners, hearing Commissioner Caston's motion, is there any discussion? I'll go first. Commissioner Caston, I appreciate your motion. I can't support it, and I'll tell you why. First, if we agreed that Duke stood up and stood out and firmly and unequivocally identified the base plan without carbon as their preferred plan or the most reasonable and prudent plan, and I don't believe that they did, but let's just say they did, I still believe there was more work for Duke to do. Now, they did a great job. Everyone says it, from the ORS experts to even some of the self-prescribed clean energy interveners, that Duke did a great job with their IRP. But the standard is not their opinion of whether or not they did a great job. The standard is most reasonable and prudent. And the General Assembly instructed us to determine what's most reasonable and prudent. And I don't believe it's most reasonable and prudent for Duke not to model any third-party solar PPAs in their IRP. So I just can't support your motion, but I appreciate and respect your position. Any more discussion?
Mr. Chairman, this is Commissioner Thomas.
Commissioner Thomas, the floor is yours, sir.
Thank you. I'm not an attorney, and so I don't necessarily look at things the same way as the attorneys do, that's for sure. And I do appreciate the legal opinions, but, you know, I have my own opinion. And my opinion is that the Duke plan does meet the requirements of Act 62. And I do appreciate all the hard work that they put into it. And I appreciate the way they work with the stakeholders. And there are things that do need to change and improvements that need to be made as we move forward. But I support Commissioner Caston's motion.
Thank you, Commissioner Thomas. Any other discussion before we vote? All right. Hearing, I'm sorry, Commissioner Williams, I see you turning on your microphone.
Thank you, Chairman Williams. Just to note that I was not able to participate in this case and thus will not be voting.
Understood. Commissioner Williams is recused from voting on this matter and did not participate in any discussion in preparing for this vote because she did not hear the case. So she is recused. All right. Before we vote, is there any more discussion?
Mr. Chairman.
Commissioner Powers.
Mr. Chairman, I also feel I cannot support Mr. Caston's motion, but would commend Duke for the hard work and the standards that they are aiming toward. I also would commend Commissioner Caston, who self-professes he is not an attorney, for the hard work he put into this motion and for his dedication and the work that he does in his position. I encourage everybody in any position that has to vote on anything to vote your conscience and to go forward. And I feel like he has certainly stood out in doing this in the manner that he did it.
Thank you, Commissioner Powers. I concur with your observation, and I think it should be noted that and it's obvious to me, but it may not be obvious to the viewers on the live stream. We used to have people in the hearing room. That seems like such a long time ago. But these decisions are not baked before they put in the oven. Commissioner Caston has worked very hard and has talked with me and talked with others, and we've been struggling with this issue. And you know, Commissioner Powers, you commended Commissioner Caston, and he knows how I feel about him, and that's positive. But I want to commend the staff because we have raked them over the coals, providing so many different motions and asking so many different questions and just trying to struggle to get this issue right. So it's been an all hands on deck approach. And I think if we're going to be successful, it will always take an all hands on deck approach, whether we all agree or not. So with that said, we'll vote starting with Vice Chair Belzer,
I vote no on the motion.
Commissioner Caston,
Aye.
Commissioner Irvin,
No.
Commissioner Thomas,
Aye.
Commissioner Powers.
No.
Chairman Williams votes no. The motion fails. Are there any other motions?
Mr. Chairman,
Commissioner Powers.
thank you, Mr. Chairman. I would move that the commission find that the companies did not prove by the preponderance of the evidence that the 2020 IRPs are the most reasonable and prudent means of meeting their energy and capacity needs at the time of review. Therefore, the companies should modify their 2020 IRPs to identify a preferred portfolio from the 6 plans presented in the IRPs. In addition, I move that the companies shall modify their 2020 IRPs in the following manner. Prepare additional load forecast scenarios, such as high and low scenarios, as required by Act 62. Make changes to its development of effective load carrying capability values and revisions to its capacity expansion modeling that incorporates those effective load carrying capability values. Remodel its portfolios using natural gas pricing forecasts that rely on market prices for 18 months before transitioning over 18 months to the average of at least 2 fundamentals-based forecasts as recommended by SEBA witness Lucas. Include third-party solar purchase power agreements priced at $38 per megawatt hour as a selectable resource. For purposes of modeling solar PPAs as a selectable resource, the company shall assume a contract term of at least 20 years with operational characteristics identical to CPRE projects. Include sensitivities in the modified RRP for PPA pricing at $36 per megawatt hour and $40 per megawatt hour. Modify its IRP and adjust its IRP modeling to account for the effect of December 2020 investment tax credit extension by Congress for solar development. Adjust its modeling as suggested by witness Lucas to take into account the increasing market saturation of single-axis solar systems in the DEC and DEP territories. In its modified RRP, Duke should use the National Renewable Energy Laboratory's annual technology baseline low figures for battery storage costs. In its modified RRP and next IRP update, Duke shall assume a 750 megawatt annual limitation on the interconnection of solar and storage resources. I further move that all IRP updates shall include the following: additional load forecast scenarios such as high and low scenarios that account for economic and other types of uncertainties or risk, use of the utility cost test when developing energy efficiency, demand side management scenarios, and saving projections in its future IRPs, IRP updates, and market potential studies. Collaboration with EEDSM Collaborative to identify a set of reasonable assumptions surrounding 1, increased market acceptance of existing technologies, and 2, emerging technologies to incorporate into EEDSM saving forecasts. Evaluation of high and low EEDSM cases across a range of fuel and carbon dioxide assumptions to better understand what level of EEDSM should be implemented in fuel cost rise or higher CO2 costs are imposed. A study of the relationship between extreme winter weather load and develop more sophisticated methods for estimating the potential impact of future extreme winter weather on load. A comprehensive coal retirement analysis to inform development in their 2022 IRP. An assessment of the risk of natural gas transportation delivery, including rejection of cancellation of pipeline projects, and quantitatively address the potential impacts of transport and delivery risks of natural gas availability and pricing. A limitation that is analytically justified, non-discriminatory, and accounts for the expected benefits of queue reform and possibility of making further investments in the company's capacity to interconnect new generation if the companies elect to impose any limitation on interconnections. a solar purchase power agreement resource option as a sensitivity. I also move that the company shall implement all commitments made in response to ORS's recommendations as described in the rebuttal testimony of the company's witnesses and is set forth in Table 1 and Table 2 of ORS witness Hayet's rebuttal testimony. In addition, I move that the company shall include in all future IRPs the following: a technical appendix that more fully describes each of the models, presents the statistical results, and shows individual energy and peak load forecast results that were actually developed. A more detailed discussion of the specific methodology used to develop synthetic loads for extreme low temperature periods. Further development of the methodology to model the effects of extreme low temperatures on winter peak load. Continued engagement with stakeholders to identify additional cost-effective EE/DSM programs to achieve greater levels of energy savings. Continued engagement with stakeholders to determine if additional EE/DSM sensitivities could be modeled, including exploration of other approaches for deriving the low EE/DSM forecasts. A review of the natural gas price forecasting methodology and investigation of alternative approaches. Enhanced coal retirement analysis methodology. Corrected capital and variable cost assumptions for combustion turbine and battery storage resources and reevaluate the reasonableness of the assumptions. An additional solar genetic resource option modeling assumptions that reflects the kind of solar purchase power agreements prices that may be available in the market. Further investigation regarding solar capacity values and solar plus battery energy storage capacity values with stakeholder input discussed as part of the stakeholder engagement process. Mini-match regret analysis and other risk analysis. Revised calculation of the average retail rate impact on customers so that the assumptions and methodologies are consistent with the calculations of present value revenue requirement, except for the levelization of the capital-related cost. Also, details regarding the status of the Southeast Energy Exchange Market, details regarding important current and planned activities, and information regarding the monetary benefits that have been and could be achieved by implementation of the Southeast Energy Exchange Market. I would so move, Mr. Chairman.
Thank you, Commissioner Powers. Hearing Commissioner Powers' motion, is there any discussion? All right, hearing none, we'll vote starting with Vice Chair Belzer. District 2, Vice Chair Belzer.
I vote aye.
Commissioner Caston.
Chairman Williams, if I may.
I'm sorry, you have something you want to read? Okay.
Just a couple of thoughts, if it's okay. I do believe that good and reasonable people can read and hear, the same information, come to different conclusions. I've heard that before, and I agree with that. That's true. I do believe that the company has complied with the statutory requirements of 58-3740 to the extent that additional detail or refinements needed. All those things said, I do think that it is healthy to have disagreements, different opinions. And, it's my great honor to not only work with this commission, these commissioners, this staff, and I've enjoyed it. I guess I'm saying all those things for this reason. I'm voting no, but
I was wondering where you were going.
I'm voting no, but this is not the first time I have been on the short end of a stick in things in life. That said, I know there's nothing personal here. I mean nothing personal. You mean nothing personal. I appreciate the way this was handled, and I appreciate the kind words. Having said all that, no.
All right. Well, I'll thank you for your explanation, Commissioner Caston. I will say if someone does not have the intestinal fortitude to stand for what they believe in, this is not the right job for him. So no one will ever be hushed or silenced or obstructed. You have all the rights and privileges that come along with the title you carry. So thank you, sir. So Commissioner Irvin,
Aye.
Commissioner Thomas,
No.
Commissioner Powers,
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, that does complete the utilities agenda for today. Moving to our transportation agenda, items 1 through 4 are applications for Class C authority, and these may be taken together by the commission, and I'll read these out. Item 1 is docket number 2021-190T, the application of BM&C Enterprise LLC for a Class C non-emergency certificate. Item 2 is docket number 2021-189T, the application of Buggage LLC, DBA Buggage for Class C charter certificate. Item number 3 is docket number 2021-187T, the application of Royal Riders LLC for a Class C non-emergency certificate. And item number 4 is docket number 2021-191T, the application of Party Hoppers LLC for a Class C charter certificate.
Is there a motion? Commissioner Powers.
I would move this commission approve the application for Class C authority. Excuse me. Mr. Chairman, I move that the commission approve the applications for Class C authority as stated by Mr. Butler in items 1 through 4.
Hearing Commissioner Powers' motion, is there any discussion? Hearing none, we'll vote starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
I vote aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 5 is docket number 2019-359T. This is a request to cancel a Class C charter certificate of Murrells Inlet Tours LLC.
Is there a motion?
Mr. Chairman,
Commissioner Irvin.
I move the commission grant the request of Murrells Inlet Tours LLC to cancel their Class C charter certificate number 9493. So moved.
Hearing Commissioner Irvin's motion, is there any discussion? Hearing none, we'll vote starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin. Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, items 6 through 8 are requests for extension. These may be taken together. I'll set these out for the commission. Item number 6 is docket number 2021-68T. We have a request from Sullivan's Non-Medical Transportation, that's SNMT LLC, for an extension of time until December 31st, 2021 to comply with commission rules and regs. Item 7 is docket number 2021-56T. This is the application of FOCI Destination Management, Inc., DBA FOCI Rides for You, for an additional extension of time until August 31st, 2021 to comply with commission rules and regulations. And item number 8 is docket number 2021-80T. This is the request of FOCI Destination Management, Inc., DBA FOCI Destination Management, for an additional extension of time until August 31st, 2021 to comply with commission rules and regulations.
Thank you, sir. Is there a motion?
Mr. Chairman,
Commissioner Powers.
thank you, Mr. Chairman. I would move that the commission grant the request for extension of time to comply with commission rules and regulations in items 6 through 8 as stated by Mr. Butler.
All right, hearing Commissioner Powers' motion, is there any discussion? Hearing none, we'll move to a vote, starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
I vote aye.
Commissioner Caston.
Aye.
Commissioner Irvin. Commissioner Irvin.
Aye.
Commissioner
Aye.
Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 9 on the transportation agenda is a request for reinstatement of Melvin Wright for reinstatement of his Class C taxi certificate.
Is there a motion?
Chairman Williams.
Commissioner Williams, you have the floor, ma'am.
Thank you, sir. I move that the commission grant the request of Melvin Wright for reinstatement of Class C taxi certificate number 8765, subject to compliance with all commission rules and regulations.
Thank you, ma'am. Hearing Commissioner Williams' motion, is there any discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
I vote aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
I vote aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, members of the commission, that completes the transportation agenda as well as all agendas for today.
All right. Thank you, Attorney Butler. Thank you for joining us, ladies and gentlemen. We will see you next week, June 23rd at 11 a.m. We're adjourned.